that the House of Representatives will not act in good faith. So, Your Honor, that's the balancing of accountability and transparency here. If you make it almost impossible, then you give the Supreme Court justices immunity. Ang presidente po, 6 na taon lang siyang immune sa suit. Ang Supreme Court justice, pag 55 years old ka na-appoint, ang sabi po nila sa mga Supreme Court cases, in fairness to them, not only now, matagal na itong mga kaso na to, hindi ka pwede mag-file ng disbarment. Hindi ka pwede mag-file ng criminal case. Kailangan impeachment muna bago mo silang kasuhan. Dahil kung hindi, indirectly tinatanggal mo sila. So kung pahihirapan naman natin ng husto kung paano sila i-impeach, maghihintay tayo hanggang 70 years old na sila, hanggang mag-retire at dun mo lang pwedeng kasuhan. Wala nang remedyo po ang taong bayan. Ang mamaya, wala nang pupuntahan.
Hindi po.
No, Your Honor, I was just responding to your thesis that it will be so easy. But I mean, I've been a congressman for 3 terms and I've been monitoring Congress. I think ilan pa lang po ang na-impeach by this mode.
I think we have...
But thank you, Mr. President. Thank you for this time.
Mr. President, the Senator Drilon...
I think we have sufficiently argued this case. But anyway, the gentleman from Iloilo is recognized.
Mr. President, I'll be very brief. The defense here, Mr. President, is making a plea that they be allowed to present evidence on their affirmative defenses because allegedly the January 18, 2012 ruling did not rule upon the affirmative defenses but only the motion for a preliminary hearing. Mr. President, the grounds relied upon by the affirmative defenses is precisely the ground relied upon when the defense asked for a preliminary hearing. And in fact, on page 2 of the resolution of January 18, it says, the Chief Justice claims that since the verified complaint for impeachment lacks a proper verification, it should be treated as an unsigned pleading which produces no legal effect and should therefore be dismissed. The January 18, 2012 ruling of this court, Mr. Senate President, categorically validated the verification. It ruled, quote, it appearing that the filing of the verified impeachment complaint was made in accordance with paragraph 4, section 3, article 11 of the Constitution, there is no more need for a preliminary hearing to receive evidence on this matter, close quote. If there was no need to present evidence on the matter of the preliminary hearing, there is no need to present evidence on the affirmative defenses. So it is not true that it was only the motion for a preliminary hearing that was denied. It is the validity of the verification itself that was ruled upon. And the purpose, obviously, of a hearing on the affirmative defenses is to have the case dismissed because of lack of proper verification, which has already been ruled upon by this court on January 18, 2012. Thank you, Mr. President.
If that commentary, Your Honor, was made by the members of the prosecution arm, we would have no objection, Your Honor. We are worried, Your Honor, that this may be interpreted, Your Honor, as an argument by a prosecutor.
I take exception to the statement of the prosecution of the defense counsel, and that is totally improper. We are just reading. I am still speaking.
Go ahead.
Do not interrupt, because I was just explaining the ruling of the court.
May I request the majority floor leader to reread the ruling of this court on what date was it?
Resolution of January 18, 2012, Mr. President.
Yeah, read it.
The Chief Justice claims that since the verified complaint for impeachment lacks proper or a proper verification, it should be treated as an unsigned pleading which produces no legal effect and should therefore be dismissed. I will just read the pertinent portions. Mr. President, to continue in the resolution, during the impeachment proceedings of President Joseph Ejercito Estrada before the Senate, case number 001-2000, A motion to quash was filed by him, alleging, among others, that the verification in the impeachment contract was not the verification prescribed by the Constitution. The impeachment complaint, the contract was probably typographical error. The impeachment court at that time found the verification to be sufficient and ruled that the perceived flaw in it was inconsequential and not fatal. Speaking through Chief Justice Hilario G. Davide Jr., who was the presiding officer of that time, the impeachment court stated in a resolution dated 29 November 2000 that verification, like in most cases, required by the rules of procedure, is a formal and not a jurisdictional requirement. It is mainly intended to secure an assurance that matters which are alleged are done in good faith or are true and correct and not of mere speculation. By Miriam Defensor Santiago. There appears to be no cogent reason to depart from this ruling. On its face, there appears to be no patent or obvious defect in the verification contained in the verified impeachment complaint. The wording or content of the same is substantially in compliance with the third paragraph of Section 13 of the Rules of Procedure in Impeachment Proceedings of the House of Representatives. It is not necessary for the verification to be couched in the language of the rules of court, inasmuch as this particularly wording is not strictly required by the Constitution. If this had been what was required, the Constitution would have specified the exact required wording of the verification. A verification is an oath or affirmation. Under the Constitution, there is only one instance wherein the exact form of an oath or affirmation is specified, and this is found in Section 5, Article 7, when the President, Vice President, or the acting President takes his oath or affirmation before entering on the execution of their office. Since there is no precise wording required for the verification of a complaint in case of impeachment under Paragraph 4, Section 3, Article 11 of the Constitution, the actual verification in the complaint as per the rules of impeachment of the House of Representatives is sufficient and adequate for the purpose. In view of all the foregoing, the motion for preliminary hearing filed by Chief Justice Renato C. Corona is denied for want of merit. January 18, 2012, Mr. President.
All right. We have discussed this lengthily.
May we recognize Senator Arroyo, Mr. President, before
The
you...
gentleman from Makati and Bicol.
Thank you, Mr. President. May I ask the defense, just what is the objective of the defense in filing this motion? What is your goal? Because as I see it, supposing the Senate will grant your request, have a hearing, and then it turns out that your allegations about the defects, etc., are true. Would you say that the Senate has to dismiss the complaint?
To us, it will appear...
Yes, I'm asking.
To us, Your Honor, it will appear that there is no valid complaint because the complaint was not in accordance with what the Constitution requires, which is the right of an impeached public official to due process. And the requirement of due process states notice and hearing.
Ergo, what you mean is that if you successfully prove your allegations, the Senate must perforce dismiss the complaint.
I do not think there is nothing illegal in that.
Well, that is precisely the problem. After 7 weeks and 27 days, we are now going to decide it on a practically the arguments that you have stated. But I was in the prosecution in the case of President Estrada. The same issue arose, the defects and all. Our argument is that the House impeaches, the Senate hears and decides. What the House transmits to the Senate, faults and all, everything, defects and all, will have to be accepted by the Senate, because the Senate cannot direct the House on how to make an impeachment complaint, because the Constitution simply says that the House impeaches, the Senate tries and decides. So, if I am thinking about the ultimate end of this goal, you're asking us to, in effect, pass judgment on what the House did. This defense is asking the Senate to decide and say the House is wrong. The House did this and did that. Now, can we do it as a Senate? The House prepares the complaint. And just like in the Estrada trial, defects and all, it was accepted. That is the President. It was accepted. That was the argument. So, in fact, let me ask for just a little while. No? Prosecution, do you have any objection to the statement of that Congressman will be presented here? This is not my question. This is what Senator Escudero, who already spoke before me, asked me to ask.
We would object, Your Honor, because the House has already performed its constitutional mandate of filing, as brought out by the good Senator. The House has the exclusive power to initiate all cases of impeachment. And the House, through that mode of direct filing under subparagraph 4 of Section 3 of Article 11, indeed filed by the vote of almost two-thirds, not only one-third. And the power of impeachment is an emergency power. Where can you find an act of a legislative body that the vote required is the minority, one-third? Because you want to make an officer accountable. So that portion...
I think that's been sufficiently explained. So, that's Justice Cuevas, my friend. I mean, that is the only question we have now. You're asking the Senate to nullify, in effect, what the House did. It's just...
If we did that, Your Honor, we have predicated our action on the decision of the Supreme Court, Your Honor, that we can raise violation of the impeached public official to due process before the House. And if it is not acted with favor, we can bring it even before the Senate.
Well,
that is the ruling of the
yes,
Supreme
but
Court.
in the Davide case, the Davide case never reached the Senate.
No, that is not the Davide case, Your Honor. I'm sorry.
I'm sorry. Whatever you're referring to.
It's the Francisco case.
Oh, Francisco case. Now, it reached only, it did not get out of the House. So the ruling was still, the Supreme Court made a ruling over a decision or action made by the House. But in this case, the Senate has already acquired jurisdiction.